A healthy adult walks into a hospital for a routine procedure and never walks out. No spouse, no minor children, just parents or grown kids waiting for answers. What most people do not know is that for decades in Florida, that death could come with almost no legal consequences. That is not a rumor. That was the law. For 35 years, Florida's so-called free kill law quietly changed how medical mistakes were treated after death. If an unmarried adult over 25 died because of medical negligence, their parents or adult children were blocked from seeking damages for pain, suffering, or loss of companionship. In plain terms, the law treated some deaths as legally cheaper than others. Supporters said this rule protected doctors and hospitals from runaway lawsuits. They warned that without limits, insurance premiums would explode, doctors would flee the state, and healthcare costs would spiral out of control. The goal, they argued, was stability. But the results told a different story. Families learned that if their loved one was killed by a drunk driver, a defective product, or unsafe property, they could seek accountability. If that same person died from a preventable medical error, the door was often shut. Same loss, same grief, very different outcome. This is where insurance quietly enters the picture. Medical malpractice insurance spreads risk across the system. When accountability is limited, that risk does not disappear. It shifts. Instead of insurers and providers absorbing the cost of failure, families absorb it. When lawsuits are blocked, insurers face fewer payouts, but the underlying mistakes still happen. Those costs move elsewhere, into higher healthcare prices, higher premiums over time, and more pressure on public systems that pick up the pieces. Critics say the law removed a powerful incentive for safety. When death costs less than injury, something is broken. Hospitals still carried insurance, doctors were still protected, but the signal to improve systems, staffing, and procedures was weaker. The market distortion stayed hidden from most people until it hit their family. In 2025, lawmakers finally stepped in and passed legislation to repeal the free kill provision. The change allows parents and adult children to pursue non-economic damages in fatal medical negligence cases. Supporters called it overdue justice. Opponents warned it would raise malpractice claims, drive up insurance premiums, and increase healthcare costs for everyone. That warning deserves attention, but it also deserves context. Insurance already prices risk. When preventable deaths are excluded from accountability, insurers are not eliminating cost, they are deferring it. Claims may rise after repeal, but those claims also expose where systems failed. Over time, safer practices reduce losses. That is how insurance is supposed to work, not by hiding risk, but by measuring it. There is also a broader effect most people miss. When malpractice exposure is artificially capped, costs do not vanish. They show up in higher charges, higher deductibles, and less transparency. Consumers still pay, they just do not see the bill labeled clearly. Florida now stands at a crossroads. The repeal opens the door to justice for families who were previously locked out. At the same time, it forces insurers, hospitals, and policymakers to confront the real cost of care. The question is not whether accountability costs money, it always does. The real question is who should pay when systems fail. For years, the answer was families, quietly, legally, permanently. Now the risk is shifting back where insurance was meant to place it in the first place. And whether that leads to higher premiums or safer medicine depends on what happens next.